What are the legal implications and risks of purchasing a domain name with someone else's name on it, even if they do not have a registered trademark for the name? So this is a question that was posted on Quora. I wrote a response to it, but feel this really needs a video to explain it better. This is not the first time I've heard someone ask this or a very similar question. So when it comes to domain names and buying a domain name that might have someone else's brands or someone else's famous name, it depends more upon what are your plans to do with that. In most cases, just buying a domain name that has maybe potentially a famous person's name or even a famous brand might not create any real risk for you, but it might limit what you could do with that. And then especially if your intent was to do something with it that would be infringing or illegal, that's where there might come some liability. So in general, even if the person doesn't have a trademark or the brand doesn't have a trademark necessarily, they might, at least in the US, have common law rights that they could use against you if you start doing something that would be infringing on those common law rights, or something that is trading off of their goodwill or diluting their trademark. It could have an issue. So it's, like I said, the intent of what you plan to do with that brand, with that domain, is really going to determine whether or not you're rising to a level of liability. If you're looking to try and sell that to that company for a profit, that could be an issue. But if you're just putting up another website that happens to be under that name, it might not be an issue. Of course, very famous brands, if you think of the Googles, the Amazons of the world, the Nikes, those names stretch much further than just what they actually sell, because they're famous. They get a lot more protection. And when we're looking at different areas of law, there's, in the US, we have the Anti-Cyber Squatting Consumer Protection Act, ACPA, and then there's also something called the UDRP, which is a Uniform Domain Name Dispute Resolution Policy. And these are tools that allow trademark owners to get domains back that include their trademark. In most of them, there has to be some show of ill will, which is why I was saying that intent is really important there. In a UDRP proceeding, all you can really get back is the domain name. But in a US anti-cyber squatting case, you can also get damages. So you could be liable for much more. So it depends on the intent. It depends what you're planning to do. There is no yes, no answer. That being said, if you think of, like I said, the famous trademarks, the Nikes, the McDonald's, the Amazons, if you try and register something with them, they're probably going to come after you, no matter what your intent is, to try and get it back. So there's a couple of words of caution there. I'll probably answer a couple more of these Quoras, so if you like them, there'll be a couple of videos that are just follows up to my answers. So feel free to subscribe and give a thumbs up. Thanks for watching.